Madam Chief Justice, and may it please the Court, opposing counsel, my name is David Thomas, and I represent the appellee in this case, Lawrence Dibble. Your Honors, to follow up on some of the comments from earlier, and especially from Justice O'Donnell, we would agree completely with the Court that facts of this case are unique, but, Your Honors, what's not unique is what happened below, and that is that the trial court and the Court of Appeals applied this Court's standards and the rules of criminal procedure and well-settled rules of Fourth Amendment jurisprudence in finding, first, that suppression was the appropriate remedy in this case, and then, on de novo review by the 10th Appellate District, taking a look at the complete record in this case offered by both parties, that in fact that ruling was correct, that it was supported by competent and credible evidence, and in fact that the Franklin County Court of Common Pleas did exactly what it has been tasked to do by the United States Supreme Court and by this Court, which is to evaluate evidence placed in front of it by the parties and make a determination about whether there has been a constitutional violation.
Counsel, what about the issue that there was a little surprise in this case because there was a preliminary issue to see whether you could even get to a hearing on whether or not there was a falsity in it, but it somehow suddenly blended into one, and at least the judge who issued the search warrant could have been a witness, filed an affidavit later, but was never a part of this proceeding.
Well, Your Honor, if there's any surprise in this case, it was brought on by the state of Ohio. This has caused all of us to take a very close look at Franks, and there's an important difference between the standard that the Supreme Court set out in Franks versus Delaware and what the state is now using in its briefs to claim that there was surprise. The state uses the phrase full hearing and then characterizes what occurred in the common pleas court here as a preliminary hearing. Well, Franks says nothing at all about that. Franks versus Delaware, all of the federal progeny and all the cases that this court has issued determining how Franks is supposed to work, none of them call for that procedure. Instead, what Franks says, and what this court has said in interpreting it, is if you're a defendant and you're moving to suppress evidence, you're not entitled to any evidentiary hearing at all unless you can make a preliminary showing. And so, at a minimum, if the state had had any problems having an evidentiary hearing, it could have entered an objection prior to the commencement of the proceeding before the common pleas court. But the record goes on from that, Your Honor. The state asked questions of the witness. The state never said, you know what, we're not entitled, or rather the defense is not entitled to a hearing under Franks because there's been no prima facie showing. And in fact, at the conclusion of the proceedings, at the conclusion of the transcript in this case, which is only 53 pages long, the state asks the trial court to make a ruling on the merits of the suppression motion. They don't say, we shouldn't have been here at all because the defense has failed to make its showing under Franks.
I have a question on the affidavit. The trial court's opinion seems to clearly hang its hat on the use of the word victim for number 2. If the affidavit had just said informant number 2 and not called her a victim, was the information in the affidavit about what happened to informant number 2, starting in her as a student and going into adulthood, would that have been permissible for the judge to consider in issuing the affidavit?
No, Your Honor. In fact, we made this argument to the Court of Appeals. As you said, if you take victim number 2 and you just make it informant number 2, and ironically that suggestion actually came from the Fraternal Order of Police as amicus, I think, there's, at the end of it, at the end of that analysis, Justice Stratton, there's just nothing that points to Lawrence Dibble's house. There's nothing, you know, that says because of this relationship that he had with you know, person number 2 or, you know,
even though he was doing all the same activities with the number 2 that he was starting to do with 1, and all that clearly looked like grooming. I mean, you know, some of that behavior was not what you would consider normal behavior for a teacher to a student. That you say that's not relevant and not admissible, even just as facts that all go to the behavior of the defendant?
Well, I may have misunderstood your question, Your Honor. What I understood was, you know, does informant number 2 sort of, does that get you into Mr. Dibble's door? Because that's really what this is about. And I would submit it doesn't. And the reason is that the behavior that was described with respect to this person, and there's ample testimony about this in the trial court record, is that there was behavior in other states and at other points in time. And
Okay, so you're just saying that, you're not saying that the trial court issuing the affidavit could not consider informant number 2's testimony or information, that it just wasn't sufficient?
I think a trial court can consider any information in an affidavit, but I think in this case, nothing about that person, however we describe her, Your Honor, points back to Lawrence Dibble's house. And I would submit part of that, Your Honor, to kind of follow
How
up
can
on.
it not point back to his house? She says in the affidavit it's alleged he took nude photos of her vaginal area during their meetings. He used a digital camera to take the photos, made her wear a pillowcase over her head while he took the photos. How does that not lead back to his house? Where do you think those photos are kept?
Well, I don't know, Your Honor. But what I would say is that, first of all, the affidavit from the affiant didn't say, well, I think it's going to be at his house. And second, it turned out in listening to the trial court testimony that, in fact, these photos were taken in other places. It was an incomplete. In other words, what I'm saying, Your Honor, is that it turned out, thanks to Franks, that information was incomplete. And then, in fact, those photos may or may not have been at his house, but if you just look at that affidavit, it's not apparent that they would have been there.
Counsel, can I ask you the first general question for me is it necessary to limit the person who's looking at the affidavit to the four corners of the affidavit to determine whether to search, to issue a search warrant?
Well, as a matter of law, Your Honor, I would say that it's not. This is the situation that Rule 41C deals with. This court's issued a rule.
This is what I'm having trouble with. At least 8 appellate courts have said generally the person who is signing the warrant to search is limited to what is put in front of that judge at the time of the request, and you do not discuss anything with the individual affiant unless that is then put in the affidavit. We have eight appellate judges, or 8 appellate courts rather, 34 cases that have said that. We have not, and I just want to clarify what your position is.
Well, our position is, of course, at the risk of making the state's argument here, there are a lot of ways that to use the colloquial, a search can be saved, that can justify an entry such as Mr. Dibble's. So the first is that a warrant is defective. That's what addresses your concern, Your Honor. And that's what Rule 41C says, is that if information is going to be given to a neutral detached magistrate, as it was here, must be sworn, must be recorded, it must be in an affidavit. I think courts have provided some other limited circumstances, but none of those apply to what's known as the probable cause analysis. They may apply to Leon in good faith, and so there are these kind of extraneous circumstances where it can apply. But on the face of it, Your Honor, I agree completely, and on behalf of Mr. Dibble, we do, that the issue is what's in the 4 corners of the affidavit and what was in front of that magistrate.
All right, so you are taking a different position from the state then? I mean, there's supposedly, if I understand it correctly, they're saying that there can be statements made to the magistrate in addition that are not recorded, and that can furnish the basis for probable cause for a search.
Yes.
You're not saying that?
No, Your Honor.
Okay, all right.
No.
Well, how about the question of whether or not it was truthful testimony or not? Not so much the substance, but whether or not it was a false testimony or not. I noticed the phrasing in the rule says, if you have the oral examination under oath, such testimony shall be admissible at a hearing if it's taken by a court. But nowhere does it say it shall not be admissible for some other purpose, does it?
Correct, Your Honor, and that's kind of a follow-up to the question we were discussing earlier. And that, again, I hate to make the state's argument here, but it actually was considered in this case, and I think it's instructive, and it's going to get to your answer, Your Honor, and that is that, in fact, what this other testimony did was it educated the common pleas court judge who was hearing the motion to suppress about the whole context of the issuance of the search warrant and the manner in which this whole situation came about. Your Honor, the trial court judge, the common pleas court judge I'm referring to, describes in his decision, he says he had an opportunity to hear all of the testimony from the affiant, from the detective who obtained the search warrant. And it was based on all of that, based on his observations of the testimony, based on, to follow up on Justice Stratton's earlier concern, other information in the case, such as the fact that he was inconsistent in his use of the term victim, because the only time the word victim appeared in the whole file in this case was in his efforts to obtain the search warrant. It isn't in any reports. He conceded that he didn't have any probable cause to file criminal charges with respect to that person, and in fact that her information was necessary in his own mind, this was the testimony, Your Honor, to gain entry into Mr. Dibble's home. So what happened here was the Franklin County Court of Common Pleas did exactly what it has been tasked with doing, which is it evaluated the evidence in front of it and was in the unique position to observe the credibility and the appearance and the demeanor of the witnesses, which is exactly what it's been commanded to do by the United States Supreme Court and by this court, and it made a determination about what, of course, has turned out to be one of the critical issues in this case. And that court was in a unique position. None of the rest of us were there, but that court did that, and it made a ruling that we submit, and the Court of Appeals agreed was supported by competent and credible evidence. And so, Your Honor, to the extent there's a problem with that, that would be an issue of error correction. It's not a new issue of law. It's an issue that the state has with how the ruling came down.
But is your argument then grounded on the basis of the use of the term victim as to the individual who was a consenting adult and not a victim? Or does your argument transcend that position?
It's part of my argument, for sure, Your Honor, but I would submit that we would prevail whether the word victim had been used or not, for the reasons I was attempting to address earlier, which is, at the end of it, there simply wasn't probable cause to believe that there was going to be some evidence of this crime regarding victim number one in Mr. Dibble's home. And so the word victim is important, for sure, and I think it's part of the context. And, you know, it's telling, Your Honor, that on the one hand, you know, the Supreme Court has commanded, and certainly in the last 25 years has said, trial court judges have to look at the totality of the circumstances. And that's exactly what Judge Horton did in this case, was he considered the totality, and as we're reviewing it here today, victim's got to be part of that totality because that's the standard that's come down from the U.S. Supreme Court. Having said that, hypothetically, I think the search is still invalid without the word victim.
Thank you.
Your Honors, just to conclude my comments, I see that my time is about to expire. What we offer to the court today is that this is not a case of unique law. This is not a case that calls on this court to change the law or interpret the law. Instead, what happened in this case is it was a case that was unique to its facts. It was a case of a police detective who overreached in a search warrant affidavit, and a trial court and a court of appeals did exactly what they've been asked to do, which they applied the standards of this court and the rules of this court in evaluating evidence and the law and making rulings. Your Honor, for those reasons, we would request that the Franklin County Court of Common Pleas and the Franklin County Court of Appeals be affirmed. Thank you, Your Honors.
Thank you. Mr. Taylor?